right, everybody ready? Okay, we'll have our second case of the morning, which is Lazaroff versus Meek, case number 2319. And again, let me know if you want something other than 5 minutes for a rebuttal.
Thank you, Judge. My name is Warren Kwobnik. May it please the Court. I'd like to reserve 5 minutes, please, for rebuttal. Okay. Again, I'm Warren Kwobnik. I represent the defendant appellant in this case, Justin Lazaroff. I know that when I come before the Court on an appeal like this, I am facing a number of burdens. One is first impressions. I assume that one of the first things this Court does is it looks at the order on appeal, and the 12-page order in this case is harsh. The other burden that I have in this case, I know, is a presumption of correctness and a deferential standard of review. In response to all those things, however, is that an order that grants new trial has to state its grounds, and those grounds must be supported by the record and the law, and this is where this order fails in large part, if not completely. And briefly to roadmap it for the Court, there was no age-related theme designed to show that Medicare would pay the plaintiff's future medical expenses. The one and only...
In a case like this, they were seeking only future damages, correct?
Correct.
Okay, and where you're talking about future loss of earnings or future loss of income, however it's phrased, you want to know how long plaintiff intended to work, but for being injured, whether that was realistic to work that long, and that evidence came out, correct?
Yes.
In fact, it was plaintiff's counsel who first asked the vocational rehab, Bradford, was that her name?
Correct, Judge.
Plaintiff's counsel had that discussion first with Ms. Bradford about how long did he expect to work, correct?
Correct.
And her answer was basically 65, maybe up to 67, and when you start talking 69, that's maybe a little long, correct?
Yes, Judge.
And then defense counsel repeated the same questions, right?
Yes.
Okay, and no objections?
No, and why would there be? Age was inherent in many facets of the case. As Your Honor points out, it was relevant in large part to the future earning capacity, how long the plaintiff might work, when he might retire. These things are unremovable from the case. In addition, it was uncontradicted that the plaintiff had pre-existing age-related conditions that, of course, the parties got into. Age was brought up just as much by the plaintiff as it was by the defendant, and not for any improper reason. It was part of the case. And with regard to the future medical expenses, plaintiff had Dr. Leber prepare a life care plan 2 years prior to trial, and one of the points that my opponent is pointing to relates to that. One of Dr. Leber's recommendations was that when plaintiff turned 65, that was an age-specific thing in his plan, the plaintiff would begin psychological testing. So one of the questions asked of Dr. Leber by the defense is, well, you made this plan 2 years ago. It called for plaintiff to begin psychological testing at 65. Has he started yet? That's unobjected to, of course, but it's a completely appropriate response for a number of reasons. One, it goes to why isn't the plaintiff doing the things he's supposed to be doing, which was our mitigation of damages defense, and also it discredits the life care plan. The plaintiff is here asking the jury to award between $400,000 and $500,000 based on this life care plan. The plaintiff hasn't started doing the things he's supposed to be doing. It discredits the plan. So
the defense counsel didn't merely talk about age 65. He talked about 2 years into the plan, supposed to be doing A. Has he done A yet? And Lieber basically, for all the questions, said he didn't know, correct?
Correct. Not all of the recommendations were tied to a specific age. This one was, which is why the age 65 was mentioned. But there were a number of things that in some...
Appellees raised the fact that Social Security came up at some point that, I'm not sure exactly what the phrase is, but basically defense lured them into saying Social Security. It was again plaintiff's expert responded to that, brought that up, correct?
Correct. It relates to the first time Your Honor referenced on the cross-examination of Andrea Bradford. Defense counsel said, and in terms of how much longer he might be expected to work, and 67 is, a reasonable retirement age, and she said, yes, Social Security calls for that. So that was something volunteered by the plaintiff's expert. And again, Social Security is not Medicare anyway, and that wasn't the subject of but
did plaintiff's counsel then on redirect ask Ms. Bradford about basically Social Security and receiving government benefits?
I don't recall, Judge. I'm sorry, I prepared as best I can. I don't remember that question. I'm sorry. But everything up to this point, I agree completely. That's the way it played out. The big picture is when the judge finds that there was an age-related theme intended by the defense to show the plaintiff would collect Medicare, no, that's completely untrue based on the record. So when we remove that age-related theme that doesn't exist, what are we left with? We're left with a singular, unfinished question about who's the largest provider of health care services. And that's not a collateral source question, and it would not have been a collateral source question. We know from the case law, we've cited in our brief the case of Anheuser-Busch versus Reese from the First District, this court's decision in Lumbermans versus Poling. These cases say that references to a collateral source payor, or even references to a collateral source itself, is not improper, and it should be allowed when it goes to something pertinent. Here, it went to whether Dr. Leber's costs were reasonable, which the defense absolutely has the right to contest. What Dr. Leber did in making his life care plan is he looked at a database, and it's like a menu, I imagine, and he pulled up the costs, and we think those costs were very inflated. So it's not a collateral source question to say to Dr. Leber, well, when you looked in your database and you pulled these numbers and you plugged them into your plan, did you consider what the largest purchaser of healthcare services might pay for these things? That doesn't say that the plaintiff is going to collect Medicare or that he's eligible for Medicare. It's, did you consider what in fact is paid for in deciding the reasonableness of the cost? That inquiry didn't even get completed, but it would not have violated the collateral source rule, and we've cited some out-of-state cases to support that that's the case. But again, we don't have to go out of state. If you look again at the Reese case and the Poling case, that demonstrates that the mere mention of the word Medicare is not collateral source evidence. The other thing, too, along those lines is, in the context of the case, we're talking about a 9-day trial where the jury heard a lot of evidence, and I detailed it in my brief, not because this appeal is specifically about the evidence, but to demonstrate to the court that there's no reasonable determination that these incidents are what caused the jury to return the verdict that they did. Over a course of a 9-day trial, the jury heard evidence that largely discredited and dismantled this case on the merits. Every claim that the plaintiff had was shown to be weak at best. That's why the jury returned what they returned. But in terms of this,
did plaintiff have pre-existing conditions, accidents, injuries?
yes. Yeah, he had.
And was that explained to the jury?
Oh, yes.
And if the jury believed those, would that have supported, not necessarily compelled, but supported the verdict that was rendered?
Yes. Yeah. I mean, he was claiming injury to his low back. He had chronic pain with pain going out into his leg, reported in the medical records, I think, a week and a half before our accident. His level of pain before the accident was reported to be basically the same level it was afterward. He was a truck driver. The use of his knee was a well-known stressor. And he had, everyone agreed, he had arthritic conditions in his knee. With regard to his brain injury claim, that too was based on a claim of unconsciousness that was all over the place and uncorroborated. At the same time, we know that the records indicate it's at least 2 prior instances related to an unconsciousness or a brain injury, all of which the plaintiff denied when confronted with medical records. He doesn't know how the unfavorable things wound up in his records. So yes, it was a largely discredited case. That's why the jury returned what they returned, not because there was a half-finished inquiry about who's the largest purchaser of medical services. Again,
is it appropriate under the Florida Evidence Code to ask an expert what the basis of his opinion is?
of course.
And is it proper to do that with a leading question?
I'm not a trial attorney. I understand that the way you ask a leading question is with a statement and then, isn't it true, or isn't it true that, or, it's raining out, isn't it? It's a statement finished with that. And in fact, if you look at the way this examination proceeded, defense counsel tried to ask it in a non-leading way. Who's the largest purchaser of medical services? And Dr. Leber said he didn't understand the question. So then it moved on to an appropriate leading question, which never got finished, and the judge decided that all of this was part of a scheme to suggest that Medicare was going to pay, which is...
Let's talk real quickly, if we can, about the 2013 CT scan bill.
Yeah.
With Meeks versus Meek, and
Yeah.
I mean, was there evidence in the record to suggest that he had prior head injuries for which this scan could have been done?
Of course.
But y'all didn't have an evidentiary basis really to get that record in?
We were not in possession. It's a 2013 scan. We don't have the scan itself. And the way that played out, the court is apparently familiar with it. In the course of discovery, we subpoenaed from the radiology service that read the films, in this case, the records. We got an invoice, and it had, on the invoice, pre-accident scans having been read as well for Mr. Meek or Mr. Meeks. We don't have the films themselves. That invoice the authenticity was stipulated to. The plaintiff had it at all times. It's mentioned in opening in a completely accurate way. We have an invoice that shows that he underwent a brain scan in 2013.
Was there an objection in opening?
Zero objection to that. And beyond that, the invoice was addressed, and the 2013 scan was addressed by both sides, I think with Dr. Boehm, with Dr. Boehm responding to a question by plaintiff's counsel by saying that 2013 scan was normal, when they went on to say that it didn't even pertain to him. And then mid-trial, plaintiff's counsel tells the judge, it's not our client's scan, because if you look at the top, it says Meeks, not Meek. The address was the same. It was plaintiff's. The other entries on the same invoice, no one says were not the plaintiff's, but because it said Meeks and not Meek, as many medical records do in this case.
Pointed out in your brief, several different healthcare providers referred to him as Meeks with an S on the end, correct?
Sure, I'm sure that happens to Mr. Meek frequently.
Was there any proof that it was not Mr. Meek's bill?
No, it was a belief, and I think plaintiff's counsel even expressed it as a belief. I believe that they combined the charges with a different person whose name is Mr. Meeks. And
let's talk about seatbelts. The court points out that y'all brought up seatbelts. Was it plaintiff's counsel who first brought up seatbelts? Actually, was it Captain Mack who volunteered seatbelts?
It was very good. Yes, Captain Mack did bring up seatbelts, and plaintiff's counsel asked some follow-up questions about that. How do you know he's wearing a seatbelt? And again, it was brought up on cross, again, by the defense, and the objection at the time, if I recall, was beyond the scope, and that was sustained. No motion for mistrial. But again, when you start getting into those miscellaneous things, I'll call them in the order, the seatbelt was really not one of the grounds for the mistrial. That was among some other, I don't want to call them throwaway points, but miscellaneous things that I think were there, mentioned at the beginning of the order, not really a ground for relief. And I think the way the order closes is by saying, for these reasons, based on the Medicare issue and the concealing evidence issue, a mistrial is needed, and especially due to these other things.
Well, concealing evidence, let's talk about that then.
Yeah, that's...
Again, the court found that y'all were making basically unfair comment on his recitation of his medical history. Is that correct?
Yes, and more specific than that. The court found that it was a missing witness adverse inference argument, which in many cases you can't say, hey, because they didn't present a certain doctor, you should infer that that person would have said something unfavorable to them.
Your argument, or counsel's argument at trial was, plaintiff said we brought you the treating doctors, and his counter to that was intended to be, yeah, well, you brought 3 out of 10, right?
That's part of it. First of all, it was not a missing witness argument at all. It was obviously a response. On its face, it was a response to what was just said. Plaintiff's counsel said, we brought you the treating doctors, the people who care about him, the people who treat him. They don't have a dog in this fight. They brought you retained experts. Two things very misleading about this. They didn't bring the treating doctors. They brought 3 out of about 10. And of the 8 medical witnesses they brought, 5 were litigation retained experts. So it's completely misleading to suggest that everyone we brought you here is a treater who just cares about this man and is not.
Plaintiff said we brought you the treaters, defendants bring hired guns, basically.
Yes, and
nicer than that, but basically.
Essentially, yes. And you know, defense, I think it was appropriate, a fair response to say that's not quite accurate. But he didn't even really make the argument. He got so far as listing some of the uncalled treaters, and then the judge, it was truncated, and the judge gave a very harsh, what the judge himself called a punitive instruction, basically saying defense counsel had done wrong, struck it and gave a curative, and in fact there was a curative for the Medicare issue also. So yes, that's the way that played out. And really those are the grounds for the new trial order in this case. And I think as we go through them, with Judge Edgeworth, you taking me through the issues you want, I think that covers it. And I think my position is that none of these grounds are supported in the record or in the law, and certainly none of them collectively or independently warranted setting aside this jury verdict.
There was an objection about the missing witness issue or argument, right?
There was an objection to that.
And once the judge raised the Medicare issue, plaintiffs then vehemently objected and moved to for mistrial, right?
Well, they did, and I think that ties into another point. One of the miscellaneous points in the new trial order is that there were just so many reasons to object in this case that the mere fact of the objections is part of what requires a new trial. But if you look at the grounds that were actually for the new trial, there was no objection to the 2013 scan. There was no objection to the Medicare. There was no objection to an age-related theme during the trial. So whatever objections are being referred to are not the primary grounds for the mistrial. These are things that either weren't issues at all during the trial or were the judge sua sponte dealing with them. I don't know if I'm in my rebuttal time.
You are into your rebuttal.
Okay, then I'll reserve the rest, if I may. Thank you.
May it please the Court, Rebecca Creed on behalf of the plaintiff appellee. We ask this Court to affirm the trial court's well-reasoned and well-supported order. There is no abuse of discretion that is patent from this record. The trial court followed the correct law and reasoned, based on its discretion, that the prejudicial misconduct of defense counsel warranted a new trial.
Let's talk about the theme of age. You agree that age was a relevant factor in this case, correct?
Yes, and the trial court recognized that as well.
You agree the plaintiff was the one who started out asking about age, and defense, at least in first with Ms. Bradford, the questions were very much the same, weren't they?
The questions were the same. The difference was, and the trial court, I would point out, also recognized that age is obviously appropriate to be referred to for certain factors and considerations. On page 1692 of the trial transcript, fair game, the length of the life care plan is this because his life is that. What the trial court was concerned about was the statement that was an intentional interjection of Medicare and a description as the largest purchaser.
Did not interject that, did they? You're talking about the Medicare.
Medicare
okay, sorry,
comment.
yeah, Medicare.
Yes, the Medicare comment, unsolicited at the end of his of his cross-examination, which the trial court considered was, based on the record, an attempt to really draw emphasis to that.
Does the judge have a crystal ball to know how that half-asked question would have been finished?
Well, he had enough to know that the statement was unsolicited based on nothing in this case, essentially defense counsel's testimony that Medicare is the largest purchaser of health care products and services.
It's a leading question. Counsel can make any leading question and the witness can agree or disagree, correct?
But in this case, there was nothing to show that Dr. Lieber used a Medicare pricing index in his formulation.
Perhaps that was the point of the question.
But there was nothing in his plan to suggest that. He had testified to the basis, his database.
Right, but you're entitled to ask an expert, why didn't you consider A, B, and C, aren't you?
Which he did ask who's the largest purchaser, but at that point in time, there was nothing to tie or to suggest that Medicare was the largest purchaser, but for defense counsel's comment, and he admits that he based that question on a 2016 report from another expert in another case entirely. The trial court recognized that there were ways that defense counsel could have gotten at the information that he was seeking, which was more along the lines of what he claimed was an inquiry into the basis for the opinions, but that wasn't the question asked, and there was no foundation. And what the trial court heard.
If Dr. Lieber if the question went out that is Medicare the largest purchaser and did you consider them, compound I understand, and Lieber said, yes, I understand they're the biggest purchaser, no, I didn't consider them. If the question had been asked more properly, more cleanly, would it have been appropriate, or do you say no?
I think the interjection of Medicare was so prejudicial in this case, as the trial court found, because it wasn't simply, it was asked in a way that the trial court considered it to be a suggestion or an inference that this plaintiff, at his age, the jury knew how old he was, would be entitled to benefits in the future, would have future Medicare benefits, and so why should the jury worry about awarding future damages or damages for future medical expenses?
Defense counsel didn't say that at all, did he?
He did not say that, but he did interject Medicare, and he did.
Medicare is used as an index for benefits, isn't it, under the PIP statute? I mean, an insurer can index payments at 200% of what Medicare pays, and it's all throughout that statute, correct?
There are contexts, and there are cases, and the defense cites them where Medicare is permissible, but those aren't the facts of this case and the way that this argument was raised.
What about, there's comments that that age 65 was a theme throughout.
Yes, and
The only thing, I mean, we've had our discussion here. I mean, again, the age at which he was going to retire, was that reasonable for his future loss of earnings? You agree that that's a legitimate line of questioning for both plaintiff and defense, correct?
yes, except to the extent that what is happening here and what the trial court found was this was an attempt to question age and tie age to future Medicare eligibility. And I would submit that Medicare.
And so you also complain or say that he,
Yes.
and I don't remember exactly the word, so pardon me if I get it wrong, but that defense counsel basically got whatever Ms. Bradford to utter the word Social Security, that it was his questioning that got that out
Yes.
there. But he, in fact, did not say Social Security. If he was trying to be a good boy and not say Social Security, he just asked about the normal retirement age being 67, right? And Bradford brought up that it was Social Security, right?
I believe I would have to look at the exact testimony.
And then it was actually plaintiff's counsel who brought up the fact that and it was Mr. Blanco, asked Ms. Bradford, is it proper to consider invoke rehab any age by which the government says somebody's going to receive benefits and cut off earning? So plaintiff brought up the fact that there were Social Security benefits available once you reached retirement age, not defense, right?
Yes, but there was an effort to tie the age to the Medicare comment. And
What about Social Security? I understand I understand your Medicare argument.
Well, the Social Security reference wasn't an independent ground for the mistrial, and the issue as to the age-related theme was considered by the trial court in conjunction with the Medicare comment.
And the other part of the theme was what? His fiancée, who is quite a bit younger, I don't remember exactly how much younger, but she talked about how his behavior or his interest had changed and weren't the same as hers, basically, correct?
Yes.
And defense pointed out the age difference?
Yes, and again, we're not raising the intention was not to raise age as an independent ground for mistrial, but it was the age in conjunction with the Medicare comment that the trial court was concerned, and the trial court was in the best position to view the impact of that
Basically,
testimony.
what you're saying, what the trial court said, was that a half-asked question that included the word Medicare in it, that's really what drove the mistrial, correct?
That's one ground for the mistrial. The missing witness, commentary is another. But yes, it's the Medicare, as the trial court found. We're inserting Medicare into it in a way, so it's an implication. Don't worry about this so much because he's going to get Medicare in the future anyway.
If he had said that, I agree that would have been horrible and a mistrial and sanctions and all the rest of it. That's not what was said, though. That's the judge with the crystal ball and plaintiff's counsel with the crystal ball putting words in defense counsel's mouth, right?
But what defense counsel started out with was just a statement that was an intentional effort to draw the jury's attention to the existence of Medicare and a description that is not supported anywhere in Dr. Lieber's testimony or anywhere in the evidence of this case as to Medicare as the largest purchaser of health care services.
This counsel would have had to have been kind of slow to bring that up with any of its experts, wouldn't it? After being chewed out by the judge for 20 or 30 pages to ask one of his experts?
Well, they didn't call a life care planning expert to refute Dr. Lieber. And so there are circumstances when it may be appropriate to reference third-party payers or average rates, but that wasn't what occurred here.
And totally relevant to say, did you take into account what health insurers pay for this surgery, correct? Because wasn't the evidence that Dr. Lieber estimated the cost of one surgery at around 130 or 150,000, and the treating surgeon had said more like 75 or 80? I mean, there's a pretty big
That
gap,
evidence
right?
came in, yes, yes.
So it would have been proper to ask, what else did you consider? He said he looked at the database that's the largest of its kind. Would it be a fair question to ask, did your database include what health insurers pay, what Medicare pays, what people, who have no money pay?
It could have been, and again, that's the trial court recognized that there could have been a foundation laid that got to this information, and the cases cited, the federal cases, illustrate that. But that's not, again, what we have here. I would like to turn to the comment on the missing witnesses. That, again, was another factor, another ground for mistrial. Oh, and one more point on the Medicare. While the trial court sua sponte basically stopped the questioning on the Medicare, we did move to strike that testimony or move to strike that comment, ask for a curative, and move for mistrial. So we did preserve that. Excuse me. On the missing witnesses, this was a comment during closing, which was 4 days after the comment on Medicare, and it was purportedly in response to plaintiff's counsel's closing argument that we brought you the treating doctors. They have a doctor-patient relationship. The defense has brought you retained experts.
I mean, that was the argument that was made, right, by plaintiff's counsel?
That was the argument that was made. There was no reference to, we brought you every treating physician, we brought you all treating physicians, we brought you only treating physicians. And defense counsel responded to that at the beginning, the outset of his closing argument, the substance of his closing argument. There's something the plaintiff's lawyer said during his opening that caught my ear. He said, we brought you the treating doctors. He then proceeds to list the 7 by name, the 7 treating physicians who were not called as witnesses here. And that is a violation of the trial court's order on closing argument, as the trial court found, and it was an attempt to comment on the failure of the plaintiff to call each of those treating physicians.
It's not just a failure to call, it's that there would be an inference that their testimony was bad for plaintiff, correct? I mean, that's the whole idea behind not permitting the missing witness argument?
That's the idea behind it, but under
When the
Louder...
plaintiff gets up there and brags, we brought you the treating doctors.
But he
it's not
doesn't...
fair to say, well, they brought you some of them.
But not to list those specific ones that everyone knew had not been called.
Well, could you have, I mean, would it have been a legitimate argument to say, well, they brought you some of them, but not all?
He could have said, no, I don't believe so, but I do think there's more harm.
Just has to basically not respond to that argument.
No, he could have said the plaintiff points to the treating physicians as being more credible or more knowledgeable. I could point out that, and I think defense counsel did point out, that the plaintiff also brought you litigation-retained experts. That was okay, but to specifically name the 7 treating physicians immediately following a comment that the plaintiff says we brought you the treating physicians, the treating doctors, and to list those 7 by name that were not brought, that everyone knew had not been called as witnesses at trial.
Was there an order on that, a pretrial order?
There was a pretrial order.
So they were violating the pretrial order.
They did violate the pretrial order because they didn't seek they didn't seek permission to raise this advanced witness inference. And the standard is not simply that at that point you had to show what that inference or that
Counsel, if
testimony
I could
would
jump
be
in.
adverse.
What is in my mind on this case is more of a process question, because I rarely see where a trial judge will sort of jump in and grant a new trial without there having been some warnings and preconditions and motions in limine and pretrial orders being violated. So here, was there any motions in limine that were made that were seeking to preclude this sort of testimony that you're complaining about?
No, there was not a motion in limine. There was the order on closing argument that set forth and cited the Louder case, which states that when witnesses are equally available to both parties, no inference should be drawn or comments made on the failure of either party to call the witness.
And just, I'm sorry to interrupt, but again, the motion in limine question I was getting at, as to any of the categories of information that are prejudicial. In other words, the Medicare. Was there any motions in limine as to any of that?
Not that I recall as to any of those
So I
specific
guess
categories.
what I'm getting at is, I'm putting myself in I'm sitting with two trial judges, and I wasn't. So I'm putting myself in the trial judge's seat and trying to figure out what was in this trial judge's mind. And it seems to me that he was getting agitated about certain things that you weren't complaining about, at least in a motion in limine, that they just sort of came up at trial. The JORG issue, the Medicare issue, I could see where, if that was going to be a feature of the trial, you might have moved in limine to prevent it. So I'm just trying to get a sense of where this trial judge was coming from to take this pretty significant action to grant a new trial, when there really weren't any sort of warnings being made early on.
I would disagree. I think there were warnings that were made throughout the trial. You can start by looking at the Medicare commentary on what the trial court viewed as improper attempts to bring in finances. That wasn't a ground for the mistrial that was ultimately granted, and I believe it was in part and parcel because of defense counsel's responses, quite honestly, to when objections were made and sustained and a motion for mistrial was made. On the missing witness, there was a standing order on closing arguments. The trial court had brought counsel's attention to that standing order many times during trial. It reminded them the defense.
That particular one is paragraph 24 that says, counsel shall not urge the jury to draw an adverse inference from the failure of the opposing party to call a non-party witness unless a proper showing has first been made with the court. So it's not to not comment on it, but to not urge the jury to draw an adverse inference, correct? I mean, that's what the order says,
That's
right?
what the order says, but it cites to the Louder case, which says no inference should be drawn or comments made on the failure of either party to call the witness. And even aside from that, there was no advance motion. There was no, although the defense sought leave to argue another issue in closing, he never brought up the fact that he intended to make this treating physician, absence of treating physician statement. And he could have.
The court commended defense counsel for being so candid in raising one of the issues that he thought about bringing up, correct? Saying,
Yes,
this is really done great, you avoided a big problem during closing by bringing this other issue up, and you're not allowed to talk about it, and he didn't, right?
Correct, but he could have done that equally with the treating physician statement. The defense knew before closing that not all 10 of the treating physicians had been called. And importantly, I would point out that the defense counsel, when questioned about this, he admits that basically his intent was to talk about. Plaintiff's counsel told you he'd presented the treating physicians. He did not. I'm pointing out he didn't. That dovetails with the representations both in closing and in argument and opening that they're going to show you the good, the bad, and the ugly. So the inference was that the defense wanted to respond to this in some belief that we had argued that we were going to bring only treating physicians, to point out the ones that weren't called, and to show the jury effectively that the plaintiff had in fact not shown the jury the good, the bad, and the ugly, that it was hiding evidence and it was not being forthcoming. And given that the credibility of this plaintiff was an issue throughout trial, the implication that the plaintiff and his counsel were hiding evidence or were not fully disclosing information was particularly harmful and prejudicial.
What if the plaintiff's argument would have been, we brought you all of the treating physicians? I realize that's not what was said, but then would it be fair to say, well, wait a minute, you didn't bring these treating physicians?
I think that would have been
So
okay
what
to
if they
say.
interpreted, or the argument plaintiff did make was capable of being interpreted that way, and defense just wanted to clarify that?
But that wasn't the argument that was made. The argument by plaintiff's counsel was not, we brought you all the treating physicians. And in fact, in his closing argument, plaintiff's counsel specifically references the testimony and summarizes the testimony of the experts who had testified at length that they didn't have a patient-provider relationship.
You agree that the seatbelts was not a basis for the mistrial, correct?
Correct.
And the reference to the 2013 CT scan, for which there was no objection, that was not a basis for the mistrial, correct?
It was considered as another example of it could be considered and
All right, well,
was
in the
set forth.
2013 CT scan bill, was there an objection raised to that?
Not to the opening statement. There were objections made to the admissibility of the invoice that showed those.
Later on, but
We-
when Dr. Beam or Baum, however you say his name, he was questioned about that as well, correct? By plaintiff's counsel.
Yes, but
So the jury already heard about the 2013 CT scan without objection and no motion for mistrial, right?
there was not a motion for mistrial directed to the 2013
Later on,
opening
when defense
statement.
tried to put the bill in, they didn't have an evidentiary
Correct.
basis,
And
but
the defense admitted at that point that.
they couldn't get it admitted into
They
evidence.
couldn't get it admitted into evidence because they had no record of
But
the
it wasn't
2013
fiction
and no
in
witness to
terms-
tie.
Ma'am,
Excuse me,
in terms of plaintiff's counsel represented that Meeks was not their client, even though it was the same address, the other treatment was the same, and at least three other healthcare providers referred to Mr. Meek as Mr. Meeks with an S on the end. He had no reason to know that was or wasn't. He believed that, and I think honestly believed it, but he had no evidence to show it was not the client's bill either, correct?
Correct. It was the defense exhibit, and I would argue they had the burden of showing admissibility. We would ask this court to affirm, and based on the cumulative misconduct and the instances of misconduct. Thank you.
Thank you.
I think the court understands my position, but I would like to make sure I address any questions that the court has.
Were there any curative instructions given as to the statements?
Yes, curative instructions were given after the Medicare reference, and a curative instruction was given after the closing argument. Yes, so yes, they were.
So they addressed the Medicare and the,
Yes, yes. The Medicare, the unfinished Medicare question, there was the lengthy sidebar, and then the jury was given an instruction that it's stricken, and they were given a collateral source instruction to the effect that you shouldn't reduce your verdict by governmental benefits. The court will do it as necessary. And then with regard to the closing argument, which of course I maintain is not a missing witness adverse inference argument, the judge gave a curative instruction that was particularly harsh. The judge knew, I mean, he said it's punitive, but he gave it anyway. And he said, the instruction violates the rule that you can't draw an adverse inference, you should disregard it, and it was improper, basically. So yes, there was no uncertain terms curative instructions given for these things. If there's no other questions, I would ask that the court reverse and reinstate the jury verdict. Thank you.
Thank you. Again, well briefed, well argued. Thank you both.